Good morning, everyone. We are on the record. First, to explain what happened last night, I've now learned more technical details than I probably have ever in my life, but essentially, the broadcast was not interrupted. And what was interrupted was there's a separate live feed that goes up to the families who are in the building and over to the media center. And that is run by a server that was knocked out by a power surge, and there was no backup. Local media have volunteered to set up a backup server for that purpose, so that if we lose the separate live feed that's going over to the media center and upstairs, that will not knock things out. It'll fail over to the other server. So that apparently knocked out only a small part of the feed. Most of the public still had their feed available, and of course we still had media people present in the courtroom, as well as a member of the Floyd family. So with that bit of information, we have a motion this morning. Mr. Frank, did you want to address it essentially this, or Eldridge, if you could note your appearance to start off with, and then we summarize basically the motion, if you would.
Good morning, Your Honor. The state has filed a motion requesting that individual witnesses who were minors at the time of the incident be exempt from audio and video recording in this matter. Obviously, there are some privacy concerns with respect to individuals who were children at the time. Many of those individuals have expressed their discomfort with being covered publicly in this court. I understand the court's order previously generated with respect to audio video stated that minors who would testify would be exempt from the video portion of the coverage unless there was consent prior, though their testimony would still be covered by audio. The discomfort still remains, obviously, for many of our witnesses. This is a very, very public trial. There is a lot of online coverage. I think, as evidenced by yesterday, even the witnesses who have taken the stand have had many hits with their names used, things of that nature. So there are some additional concerns that we have with respect to these children. 4 of our witnesses were children at the time of the incident. 2 of them still are minors, but those concerns are that those individuals, these are children who did not choose to be a part of this case. These are individuals who were going about their day and happened to see a man die before their eyes. And they didn't choose to be part of this process, and they're going to have to live with being a part of this process for the rest of their lives. So we want to make sure that we are adequately addressing their privacy concerns. Obviously, it's something that is pretty commonplace with respect to child victims and witnesses. It's pretty standard for court documents to refer to minors by their initials or by some pseudonym. If the court is inclined to maintain the audio coverage portion of these individuals' testimony, we would at least ask that the court consider use of pseudonym with respect to the individuals just using their first names to refer to other individuals' first names who were minors at the time. I did speak with Mr. Nelson about this briefly this morning. I understand that the defense does not object to us using only first names with respect to any of these individuals who were minors at the time. And obviously the reason for that is we want to make sure that we are protecting the interests, the privacy concerns of these individuals, and honoring those wishes, Your Honor.
All right. Ms. Walker, did you wish to respond on behalf of the Media Coalition?
Thank you, Your Honor.
And you can remove your mask if you'd like.
Thank you, Your Honor, and thank you for making time for the Media Coalition to be heard this morning. If the court wants to instruct the trial participants to refer to these, frankly, to any witness by their initials or by their first name, the Media Coalition has no objection to that. We want a right to live stream what happens in court, and whatever they're called when they're on the stand is what will be live streamed. I understand the court may be contemplating allowing at least 2 witnesses who remain minors to identify themselves with the audio turned off, and then turn the audio on for their actual testimony. And, Your Honor, the coalition has no objection to allowing the 2 witnesses who remain minors to do that. You know, as a practical matter, I think it's easy to figure out who they are by their initials. Their names appear on the witness list, and there should not be a prohibition on reporting anything that's already public. But if it gives these minors some comfort to not have to say their name with the audio on, that's fine with the media coalition. Let me talk just a minute, though, about the notion of turning the audio off and also turning the video off for the 2 witnesses who may have been minors at the time of the events in question but are now adults. And we really view this, Your Honor, as a second motion by the state for reconsideration of your November 4th order. Your order was very clear. You stuck by that order on their first motion to reconsider, and we really don't think you ought to entertain a second motion to reconsider. One witness in particular, Your Honor, is particularly important to this case. Her initials are DF. You know, the media coalition is sympathetic to the personal cost she bears in coming to testify, but she's an adult now. Her testimony will be key. My understanding is that she is the bystander who filmed the viral cell phone video that is at the center of this case. And while what she saw may have been traumatic, she's an adult. And I think it's important to remember that 2 things. One, I wanted to say that the state just said that many of the witnesses have expressed discomfort with audio, video. I don't know if that was an intentional hedge, Your Honor, but if DF has not expressed discomfort, then we don't really even need to be talking about it. And I question whether she has, because she has in fact been quite public. And just to give you a sense, she was interviewed by the Star Tribune shortly after George Floyd died. She's authorized her attorney to speak to the press, including after she was publicly commended by the chief of police. She's furnished photographs of herself to the Star Tribune and other media. She publicly received in a virtual gala an award from Spike Lee. That video remains online, including on the Star Tribune's website. And as you all probably know, just a couple of weeks ago, she posted about jury selection to her public Facebook page. So for all of these reasons, and that was covered by the Star Tribune as well, I have a link if you're interested. It's a little bit farcical to suggest that no one knows who she is. She is an adult, and we believe she should testify publicly both on audio and video, consistent with your November 4th order. That's true for the other adult witness who may have been a minor at the time, although again, I don't believe that person has been quite so public with her involvement in this case. But we believe you should stick by your November 4th order. I'm happy to answer any questions on that.
Well, first of all, any broadcast is an expansion of the rules, so you would agree with that. The fact that I am broadcasting anything is...
Yes, but I believe you were correct that the rules must bow to the First Amendment in this case.
All right. Thank you. All right. As to the state's motion to restrict the audio feed of the 4 witnesses, all of whom were minors at the time, 2 have since turned 18 years of age, I'm going to deny that motion with one exception. So essentially, their testimony will be allowed by audio. As to all 4, I'm going to allow them to, after they receive the oath, to state and spell their names, but off of the audio feed. So that will not go beyond this courtroom. Much as we dealt with jurors who were discussing private matters during jury selection. They may be referred to by first names by other witnesses. That's fine. So essentially, my order as far as audio is the same as previously ordered, with one exception, that being their names will be given and spelled in the courtroom, publicly, on the record, but without the audio feed going out. As to video, I am going to, even though two are technically 18, given their young age, I'm going to continue to suppress the video for those minors as well, all of whom object. At least that's my understanding. Is that correct?
That's correct, Your Honor.
All right. All four of those witnesses do object to video, and thus I know technically that two are now adults, and it's Ms. Walker is, I'm sure, very correct that people will be able to figure out who these people are. But in order to give them, this is more to get testifying as witnesses in what is a very high-profile trial. And given their young age, I am going to grant it as far as these four witnesses, but no others. So no video at all, audio as previously ordered, with the one modification that their names will be not given out over the audio feed. Now, having said that, media is present. They can report out the full name. I cannot impose a prior restraint on that. And so it is going to be said in a public courtroom. I would note that allowing the audio stream, despite their discomfort, when we compare to what we put, for example, a young criminal sexual conduct victim who has to testify about deeply traumatic and terrifying sexual abuse sitting in front of their abuser, with the public present in a larger courtroom, I think we do unfortunately have to ask a lot of our witnesses, especially ones who are minors, who are victims, and who are victims of terrible trauma. These, on the other hand, are witnesses. They are not victims per se. I'm sure it had an effect on them, but they are not victims per se. They are bystanders testifying about what they saw happening to Mr. Floyd. So with that, any questions about the court's restrictions? All right, and we are going to have all four of them come one after the other. Is that correct?
Yes, Your Honor.
All right, and for those four, one requires a support person. Is that correct?
That's correct.
We have a second chair set up right next to the witness stand, and the TV feed will not include that support person. At most an elbow, but even then we're going to try and keep the camera shot very tight just on the witness. And for the minors, it's not going to be on at all, so it's not going to be a problem.
Very good.
The camera will be on the seal. Okay, I think, is there anything else? The jurors are starting to arrive, but I don't think we have a full complement yet. Anything else for the record?
Nothing from the state, Your Honor.
All right. The earliest we're going to be able to start is 9:15 if we have everybody, but let's 9:15 at the very earliest, probably 9:30. Thanks.